I'm Drew Stevenson. This is a lecture for my administrative law class about the case Center for Auto Safety versus the National Highway Traffic Safety Administration. This is a DC Circuit Court of Appeals case from 2006 about legislative rules or regulations and agency policy statements. A couple quick words for my students. To put this in context, remember that the Administrative Procedure Act in Section 553 has a section about what it calls informal rulemaking, but is really notice and comment rulemaking. So when agencies promulgate an official regulation, they have to publish a proposed rule in the Federal Register, allow a public comment period, and when they publish their final rule some months later, they also have to kind of respond to some of the comments that they've gotten from, usually from the regulated industry or to citizen activist groups. So in the beginning of 553, there's an exception for certain things that agencies do or that they don't have to do notice and comment rulemaking for, or the section doesn't apply to that. And the most important ones are general statements of policy and interpretive rules. So an interpretive rule would be something where the agency says, this is how we're interpreting our own regulations as a general principle. And the statement of policy is typically an announcement of enforcement priorities or non-priorities, like we're not going to bother bringing enforcement actions over these low priority or low harm cases. Or if it's something where, like in this case, where the agency has to review proposals from the regulated industry, where they sort of have their what kind of standards or rubric they're going to use for analyzing and approving or disapproving these proposals. Agencies have an incentive to characterize what they're doing as a general statement of policy or interpretive rule, so they don't have to bother with the time and headaches of notice and comment rulemaking. It can really take a long time and in itself can generate litigation and so forth. And so this tendency, this kind of workaround or evasiveness that agencies use generates a lot of litigation because the regulated industry doesn't like their guidance document or policy statement either and wants them to at least have to go through the hoops of notice and comment rulemaking. And the other thing to keep in mind about this particular area of administrative law, besides that we get a lot of cases about this, when you're in practice, you're likely, if you are representing, doing regulatory work, you're likely to encounter this issue. We get a lot of cases and they're kind of all over the place. And so your casebook probably has two cases back to back about agency guidance documents where, and the court says in one case, this is really a de facto regulation, you should have done notice and comment rulemaking. And in the other case, they say, this is fine, you don't have to do this, this is just a statement of policy. And it can kind of leave you scratching your head, well, was there really a difference or is it just day of the week? And that's a good question. We have standards, we have some factors, but the cases are hard to predict and they come out each way, even to this day. So if you are a person who really likes a clear, predictable, always know what the right answer is, this is going to bother you because the cases are still kind of inconsistent. So let's go back to our case and see what happens. Our big takeaway, by the way, I know this is a little boring and I'm afraid you're going to give up on me, so I'm going to tell you the main takeaway up front is the circuit court, this is the DC Court of Appeals, held that the NHTSA's policy guidelines that covered automakers' voluntary regional recalls amounted to a general statement of policy, not really a binding rule or regulation, and therefore were not subject to judicial review. In other words, no judicial review in this case under the APA. So let's talk about the statute. In administrative law, we always pay a lot of attention to the statute. It often matters more than the facts or the parties or anything else in the case. So we have a statute that's the National Highway Traffic Safety Administration Authorization Act, which the court conveniently shortens to the Safety Act most of the time. And this permits car makers to initiate these voluntary recalls when they discover that one of their cars they've already been selling has a safety defect or is out of compliance with some safety standards. And the if you own a car, you may have gotten one of these recall notices. What they usually do is direct the consumer to go to a repair shop, an authorized dealer or repair place, and they will replace a part or fix whatever the defect is for free. And this is actually a big part, maybe the biggest part of how we regulate car safety in this country is we have some safety standards, and then the car makers do a lot of these recalls and they don't take the whole car back. Instead, the people who bought the car are supposed to take it in and get that part replaced or fixed. And then we have an agency, and that's the NHTSA, or the National Highway Traffic Safety Administration. They are a subdivision of the Department of Transportation, and they administer and implement this act and monitor manufacturer recalls. Okay, so in the 1980s, the car companies adopted a practice of doing regional recalls, because it turns out that if you have a car in South Florida on the coast, or the Florida Keys, it is in a very different climate and encounters different types of environmental issues, like sea salt and heat, than you might encounter in Buffalo, New York, or Montana, where they use a lot of salt on the roads, and so to melt ice and snow. So I teach in Texas, my students might not be familiar with this. In the northern climates where you get a lot of ice and snow all winter, they don't just plow the roads, they have these kind of big dump trucks that go around and spread salt and sand on the roads, which it melts the snow and ice. And they usually do that in addition to plowing. So this is, by the way, rots the bottom of your car out. The salt is really bad for cars. So the example is, if cars suffer a lot of corrosion when exposed to salt, these manufacturers would do recalls in states they use the most salt on their roads in the winter. So if you live in Oklahoma, let's say, or New Mexico, you might not really encounter this. Your car might last a lot longer, depending on how the car is made and the undercarriage of the car, than that same car would last in Nebraska or North Dakota, where it's going to get exposed to 3 or 4 or 5 months out of the year of having a lot of salt on the roads. So the agency in 1997 issued some policy guidelines without going through notice and comment rulemaking procedures about when manufacturers could use these regional recalls to satisfy the statutory recall requirements, which they were already doing. And basically the NHTSA was trying to say they were supposed to approve it, and instead of having everything sort of be on a random case-by-case basis, they were trying to sort of channel these into being done a certain way. So these guidelines indicated that these recalls actually would be approved for car issues if the manufacturer could show that they were clearly related to regional environmental factors, like salt on the roads in states where there's a lot of snow, or maybe in the Gulf Coast states, the saltwater and sea air and storms and flooding that can affect cars. So the guidelines also set forth a specified minimum region for the recalls based on road salt corrosion. In other words, the agency really didn't want car manufacturers just recalling cars from one city or county. They wanted to kind of have it be larger regions. And they required car makers to discuss potential geographic limits with the agency before issuing these recalls. And so enter these our plaintiffs here, which is a couple of consumer advocacy groups. One is called the Center for Auto Safety. And yes, their logo is depicted here. It's a lemon with wheels. Um, and they sued the agency, claiming that this policy of allowing regional recalls was not allowed actually under the act itself, under their enabling statute. It violated the act, they alleged. And they also claimed that the guidelines should have gone through notice and comment rulemaking. So as an aside for my students, notice usually we have the regulated industry challenging these guidance documents, but here it's the other groups that sue agencies basically saying that they're selling out or being too lenient, and those are citizen advocacy groups or special interest groups, depending on your perspective, that want the agencies to do more to protect the public from fraud or safety problems and so forth. And so basically they thought that the agency wasn't really doing its job under the statute by allowing the car makers to do these regional recalls. Instead, they kind of wanted to force the agency to force the car makers to do recalls for all the cars nationwide if they had this problem. And so, and by the way, this may seem like they're just being difficult, but I hope you can see that you can easily have a car that's originally bought or sold in Texas end up in Montana, right? Through when it's sold, where it's going to encounter a very different environment. And so that's kind of what's going on in the minds of our plaintiffs here. Okay. So the court here decided that it actually did not have jurisdiction to review the NHTSA's actions because the guidelines were just a policy statement and they weren't a legislative rule. They use that language. A lot of these cases use that phrase a lot, so you should watch for it. And therefore, they didn't constitute a final agency action, so therefore, there's no judicial review. We may not have covered that issue yet in your administrative law course, but just trust me, that if under the APA, in order to get judicial review, it's a prerequisite that you have a final agency action. And the court here is saying, we don't have that with these guidance documents. By the way, I pulled out something I think you should really notice in the case, that the court emphasized 3 points in explaining why the guidelines were not a legislative rule. And the reason this matters is this could give some guidance or be something, the part of the case that's worth citing or applying in future cases. First, they said the guidelines didn't purport to have the force of law, like on their face. They basically said they weren't legally binding. And they were also phrased like guidelines with kind of general principles and a lot of conditional language instead of being phrased like in more absolute terms or clear-cut terms like regulations usually are. Also, the NHTSA wasn't bound to follow them. And this is a little different from some of the other cases we study where the agency itself is always going to the agency personnel have to follow a certain what's in the guidance document, which sort of creates a pass-through requirement for the regulated industry. And that wasn't the case here. The NHTSA staff could deviate from these principles in special cases. You might remember the requirement that car makers actually have a discussion or negotiation with the agency about the recall. So the agency actually had quite a bit of leeway still, even with these guidelines on a case-to-case basis. So even though the manufacturers had been adhering to these guidelines for 7 years at this point, the court also held that this practical effect didn't transform the guidelines into legislative rules that required notice and comment, or that constituted a final agency action that would then trigger the judicial review provisions of the APA. In other words, the plaintiff, Center for Auto Safety, said, look, the manufacturers are all basically following these guidelines for regional and doing these regional recalls. So they have become the law because they're influencing or controlling the practice of the industry. And the court said that basically the fact that what people are actually doing doesn't make something law or give it the force of law and trigger things like judicial review or the duty to do notice and comment rulemaking. Okay, that concludes our lecture about the Center for Auto Safety versus the NHTSA.